Contesting a will involves challenging its validity or certain provisions within it. Here are the general steps to contest a will. 1. Grounds for contesting. Identify valid grounds for contesting the will. Common grounds include lack of testamentary capacity, undue influence, fraud, forgery, or the existence of a more recent will. 2. Consult an attorney. Seek advice from a qualified attorney who specializes in estate litigation or probate law. An attorney can assess the circumstances of the case, determine the strength of your claim, and guide you through the legal process. 3. Review the will. Obtain a copy of the will and review its contents carefully. Note any provisions or circumstances that raise concerns and could form the basis for contesting the will. 4. Gather evidence. Gather evidence to support your claim. This may include medical records, witness testimony, financial documents, correspondence, or any other relevant evidence that supports your allegations of undue influence, lack of capacity, fraud, or other grounds for contesting the will. 5. File a petition. Prepare and file a formal petition with the probate court to contest the will. The petition must state the grounds for contesting the will and provide supporting evidence. Depending on the jurisdiction, there may be specific deadlines and procedural requirements for filing the petition. 6. Notify interested parties. Serve notice of the petition to contest the will on all interested parties, including the executor or personal representative of the estate and any other beneficiaries or heirs named in the will. 7. Litigation process. Engage in the litigation process, which may involve discovery, depositions, hearings, and possibly mediation or settlement negotiations. 8. Court hearing. Attend a court hearing where your petition to contest the will be heard by a judge. Present your case, including evidence and arguments supporting your claim. 9. Decision. The court will consider the evidence and legal arguments presented by both sides and make a decision on the validity of the will. If the court finds in your favor, it may invalidate all or part of the will and determine the appropriate distribution of the estate assets. It's important to note that contesting a will can be a complex and contentious legal process, and outcomes can vary depending on the specific circumstances of each case and the laws of the jurisdiction. Working with an experienced attorney can help ensure that your rights are protected and that you navigate the process effectively.